Hello friends, I am Advocate ARPIT SAXENA. You are most welcome at my YouTube channel, the Rampup. Today I am going to discuss a very important difference in between the bailable and non-bailable offense. To understand the criminal law and the law regarding the bail, there is very needed and necessary to understand this difference properly. So let's start the video. First of all, I would like to tell you about the first schedule of the CRPC. In this schedule, all the offenses defined in the IPC is there, and the nature of the offenses can be easily understood by the study of this table. So you may easily understand the which offense shall be bailable and non-bailable by the study of this table. But for the offenses which are not mentioned in the IPC, you have to go to the last of this table, and there is also a one short table is there by which you can easily understand the which offense shall be bailable and non-bailable. This table is for the offenses which are not mentioned in the IPC. So there is a one table like that. Any offence which is punishable with less than 3 years of punishment shall be bailable, but all the offences which are punishable with more than 3 years of punishment shall be non-bailable. So all the offences which are punishable with more than 3 years of punishment but less than 7 years of punishment shall be non-bailable but triable by the judicial magistrate first class, while all the offences which are punishable with more than 7 years of punishment shall be non-bailable as well, but shall be triable by the court of session. So this is the one important difference in between the offenses which are punishable with 3 to 7 years of punishment and with punishment more than 7 years of punishment. So now come to the actual difference in between the bailable and non-bailable offense. There is a one important difference that the bailable offenses are generally less heinous and barbarous, like 494 bigamy, 497 500 defamation. However, the 497 have been declared unconstitutional by the Honorable Supreme Court. But the non-bailable offenses are generally more heinous and brutal, like 498A, murder, rape, extortion, dacoity, theft. So such type of offenses are more heinous and brutal in the nature. Now come to the one important difference in between the bailable and non-bailable offense. It is that in a bailable offense you may claim the bail as a matter of right, but in a non-bailable offense you cannot claim the bail as a matter of right. This is the one of the most important difference in between the bailable and non-bailable offense. However, there is some exception as well. In a bailable offense, if you have been granted with a bail, now there may be some conditions which may be attached with the bail order, and the released person is bound to follow such conditions, and in case of any of breach, such person may be refused to be released on bail. This is mentioned in section 436 clause 3 CRPC. Now come to the exception for the non-bailable offense. After the expiry of 60 or 90 days, after the expiry of 60 or 90 days means if the charge sheet has not been submitted within the 60 days or 90 days, arrested person may be entitled to be released on bail. This bail is known as default bail. It means if the charge sheet has not been submitted within 60 days, where offense is punishable with less than 3 years of punishment, or in a 90 days where the offense is punishable with more than 10 years of punishment, the arrested person shall be released on bail. So this is known as a default bail, and the accused and the arrested person shall have a right to be released on bail. Now come to the second exception. If the maximum period of imprisonment for the offense has been undergone by the arrested person, now under section 436 clause A CRPC, that arrested person shall be entitled to be released on bail. So these are the two important exceptions of the general rule that in a non-bailable offense, bail cannot be claimed as a matter of right, and the bail is subject to discretion of police officer and the concerning court. So this is the general rule, but there are some important exceptions. There is also one important difference, that in a bailable offense, non-granting of bail is not treated as a good law. So in a bailable offense, arrested person is entitled to be released on bail, and the bail should be granted. Now 436 CRPC is the important section which govern the provision regarding the bailable offence, while the 437 CRPC govern the bail into the matters of the non-bailable offence. This is the important distinction in between the bailable and non-bailable offence. You may easily understand by the pausing of this video. I hope you would like this video, so please like and share and subscribe. Namaskar, Jai Hind.